I have some troubling and concerning news, especially for members of the military. According to a recent memorandum issued by the Acting Director of Immigration and Customs Enforcement, ICE, even active-duty members of the military could be subject to deportation. The memo, titled Consideration of U.S. Military Service During Civil Immigration Enforcement Actions, instructs all ICE employees that U.S. military service alone does not automatically exempt aliens from the consequences of violating U.S. immigration laws. Even active-duty service members may face deportation, which is quite shocking. The memo notes that ICE will generally not issue a notice to appear, NTA, against an alien currently serving on active duty, unless there are significant aggravating factors. However, it also confirms that ICE is not prohibited from placing active-duty aliens into immigration proceedings. Furthermore, the memo clarifies that an honorable discharge does not necessarily protect an alien with U.S. military service from immigration enforcement actions. Receiving an honorable discharge means a person served honorably and did not commit crimes. While it is understandable that service members who commit violent crimes could face deportation, such individuals typically would not receive an honorable discharge. Certain provisions in immigration law allow non-lawful permanent residents to acquire what is often called instant U.S. citizenship through military service during periods of armed conflict, including the ongoing war on terror since 9/11. Many service members are eligible for U.S. citizenship under these provisions. However, some service members may not qualify for citizenship, for example, if they were not physically present in the U.S. at the time of enlistment, and may still be subject to deportation, even while on active duty. This is particularly concerning as many immigrants who have not served in the military are anxious about enforcement priorities under recent administrations, hoping for mercy due to factors such as age, family ties, or long-term residence. If ICE is willing to deport active-duty military personnel, including those honorably discharged and without criminal records, it will be increasingly difficult for non-military immigrants to avoid deportation. Active-duty members of the military are patriotic individuals risking their lives to protect our freedoms, yet their futures in the U.S. are at risk. Previously, many handled immigration matters without legal assistance to save money, only consulting attorneys after case denials. That approach may no longer be viable. Under current or returning policies, if your case is denied by USCIS, whether due to missing documents, incorrect forms, or errors, you may face immediate deportation proceedings. An NTA can be issued upon denial, as denial places a person out of status. Therefore, it is crucial to seek legal advice early. An attorney can evaluate your eligibility, help prepare forms correctly, and gather evidence to strengthen your case. If even active-duty military members with honorable discharges can be subject to deportation, so can others. I hope you found this information helpful. I will continue posting updates to keep you informed about the immigration climate. It is becoming increasingly challenging, but stay strong.